Welcome back to our session on company law under KB3 commercial law subject of your syllabus. Last time we ended up talking about shareholding in a company. Now I explained that as per the company's law in Sri Lanka, you need to have at least 2 shareholders to constitute or to incorporate a company, and there was no provision for a single shareholder companies under our law. This stems from the British law, but however certain legislative developments took place when the new Companies Act number 7 of 2007 was adopted in place of the previously enacted law, which was number 17 of 1982. Now what previously existed under the Companies Act of number 17, 1982, it had provisions only for a minimum number of 2 shareholders to form a private company as per section 2, while section 3 of the old Joint Stock Companies Act required a minimum of 7 shareholders. So the minimum number of 7 shareholders was reduced to 2 when the Companies Act 17 of 1982 was enacted. With the repealing of the latter, the Joint Stock Companies Act, this minimum number was brought down to 2, as I said. Thereafter, there were so many concerns about bringing the number down to 1, mainly because of the fact that many businesses were under proprietorship, and these proprietorship businesses were to be converted on the wish of the proprietors, like that Solomon Company, what we discussed in the case of Solomon versus Solomon and Company. There, our law focused on bringing down this number to 1. Many proposals were made at the time of creating the Companies Act number 7 of 2007, especially as I mentioned, due to many family businesses existed with only 1 controlling shareholder in private companies, compelling 2 shareholders to be in such companies in order to fulfill statutory requirements, so that to bring in an additional shareholder just for the purpose of fulfilling the statutory requirement. Later, persuasion was had to reduce the number to 1 shareholder, despite the English company law that required 2 to allow proprietorships to transform into companies, as I mentioned. Now what made out to be the compromise in the Parliament of Sri Lanka? The Bill of Parliament dated 19 October 2006, when it was brought into the Parliament, included provisions to allow a single shareholder companies having 1 natural person, that is a human being, in addition to allowing a corporate body or a treasury appointment in a case of a public company to form a new company. Finally, subsection 2 to section 4 was added in the Companies Act to read as, a company shall have not less than 2 shareholders. So the minimum requirement was 2. The word shareholders made to include provided that a company may have a single shareholder, where such single shareholder is an individual or a body corporate or the secretary to the treasury who is holding shares on behalf of the government of Sri Lanka. That is to pay way for the incorporation of a company with that 2 shareholder minimum requirement, having one natural person and a body corporate, or one body corporate with another body corporate being a shareholder, or that the secretary to the treasury to be made a single shareholder in case of a public company. So, 2 human beings, or 1 human being with another corporate body, or 1 corporate body and another corporate body, which was made possible in addition to the fact that the secretary to the treasury in Sri Lanka can be the sole shareholder when it comes to a public company. Many who read this section 4 subsection 2 come across these complications, whether a single shareholder company can exist in Sri Lanka. But however, section 4 subsection 2 very specifically mentions that at the beginning, any company to be incorporated in Sri Lanka shall have at least 2 shareholders. But out of these 2 shareholders, it can be at least 1 natural person to be a single shareholder. But otherwise, it has to be 2 single natural persons, or 1 single natural person with a corporate body, or 2 corporate bodies to fulfill the requirement of being 2 shareholders to incorporate a company. I guess it's clear for you all now that a single shareholder company cannot exist unless otherwise it is satisfied on those bases. Let's look at the rights and liabilities of shareholders. What are the rights and liabilities of shareholders? A shareholder status cannot be altered unless by special resolution, which means that once a shareholder subscribes shares, he automatically becomes a shareholder, and this particular shareholder would remain as a shareholder as long as the company exists, so that the status cannot be altered of a shareholder. But however, a special resolution passed by the company can either remove a shareholder or buy back that shareholder's share to somebody else in the company, or bring in a new shareholder in place of the other natural person or the corporate body. Shareholder has the right to vote at all company meetings of the shareholders, annual general meetings, extraordinary general meetings, and so on. So, the shareholder's powers is a kind of a veto, where his right to vote naturally gives the shareholder an upper hand. Also, the shareholder has a power to make his view on altering company's articles, and the shareholder can pursue in the general meetings of the company to effect such amendment, alteration according to his proposal. Shareholder is the one who has the power to approve a major transaction in a company, a major transaction. Now, major transactions of a company are something beyond the control of the directors of a company. If I may clarify further, and I take you through the provisions of the company law, the major transactions are that the company is affected by any major transaction that it may take up in the company's name. Actually speaking, the directors of a company, without the sanction of the shareholders, cannot take decisions on major transactions, since these major transactions affect the company to a great extent. So, therefore, with regard to a major transaction, the shareholder sanction is very important, and these things have to be approved either in a general meeting or in a specially summoned meeting of the shareholders convened for that particular purpose. Also, the shareholder can approve an amalgamation of the company with another company. If an existing company is expected to amalgamate with another company, especially in the case of a buyback or in a transaction where this particular company invests in another company, then such as a merger and acquisition, such approval for the amalgamation of the company shall only be taken by the shareholders and not by the directors of the company. Shareholders are the ones who have the power to reduce the company's stated capital and also to move for any future investment by selling its shares to raise the capital of the company. Shareholders have the power to change the name of the company and inform the registrar of companies to effect same, and also to change the status of the company, probably starting as a private company and thereafter move into a public listed company, PLC, where at a certain stage of the company affairs and the company incomes and profits have grown and passed the threshold of becoming a PLC, then in such a case the company shareholders have the power to change the status of the company from a mere private limited company to a PLC. It also requires the company to purchase minority shares, what we call the minority buyout. If the shareholders intend to buy out certain shares of the minority shareholders in a company, such a decision has to be made by the shareholders. So, the shareholders have the power to effect such a minority share buyout, and also to take action against oppression or mismanagement of the directors or against the directors, including any injunctions, temporary enjoining orders against these directors who acting in oppressive manner or in mismanagement. The shareholders can go to court under the Companies Act to seek the court intervention to prevent company affairs being mishandled, mismanaged, or handled in a manner oppressive to the interest of the company, and sue the directors and obtain relief from court, either to remove the directors or to get the directors to comply with the Articles of Association and bring in smooth operation for the company's business activities. In doing so, as I mentioned, the shareholders can rely upon enjoining orders and injunctions to prevent such directors from acting in an oppressive or mismanagement manner until the final decision is being granted by the court, or the final relief rather granted by the courts. And also one specific type of action that the shareholders can get through the court or institute through the court is the derivative actions. Derivative actions where the acts of the shareholders have caused tremendous prejudice to the shareholders, then the shareholders have the power and the right to seek from the court what we used to call a just and reasonable solution, just and equitable solution, to prevent these types of bad actions committed by the directors of the company. So, these mismanagement derivative actions we will be discussing later on in length. And let us now talk about the rights and liabilities of shareholders with the view of understanding. Now we talked about the rights, but now the liabilities. The primary liability on a shareholder depends on the type of the company against the shares held by such a shareholder in question. So, primarily if the company is a limited liability company, every shareholder shall be liable to provide the share value as and when the company calls for it. If it is an unlimited liability company, then to be made themselves unlimited at the time of a liability issue arise. If it is guarantee company, then the shareholders have already guaranteed to provide the funds required as against the assets of the company to fulfill the debt burden of that company by supplying the finances necessary to meet those debts. Then a pure private act of a shareholder in terms of contract, tort or fiduciary duty or other actionable wrong, when committed by a shareholder, the court can always pierce the corporate veil or lift the corporate veil, as we say, to identify who is behind the curtain or who is behind the veil, and then impose such liability upon such shareholder, making such shareholder liable for the actions taken or the decisions taken by such shareholder in detriment to the company's interests. So therefore, if a pure private act has been committed by a shareholder that violates the law of contracts, law of tort or civil wrong, or anything fiduciary, trust, or committed fraud or whatever other actionable wrong, then this corporate veil will be pierced or lifted and identify the particular shareholder who has committed such a private act to the detriment of the company, and such shareholder will be liable towards the company for acting in such a way. And also, if the shareholder is called to pay for the shares, the shareholder is liable to pay such share in respect of such call. At what circumstance can a shareholder be exonerated from liability? If any act, default, or obligation of the company itself has been committed, shareholder will not be liable, or rather the shareholder shall be exonerated from any liability. So where the company itself has acted wrongfully or in default or in violation of the company's obligation, then the shareholder or the shareholders will not be held liable. Now one may wonder, how can that happen? Because the company is an artificial person. Company can't take its decisions. It is the shareholders who have to take the decisions. It is the shareholders who have to run the company. Perfectly right. But suppose that there are several shareholders. If certain number of shareholders have done the wrongful acts, then the innocent shareholders shall be exonerated from liability. In the other case, if the directors have done something wrong without the knowledge of the shareholders, and that the shareholders have not sanctioned such an act of the directors, then in that case the directors become personally liable, not the shareholders in particular. So any act, default, or obligation of the company which has been committed wrongfully, then shareholders shall be exonerated from the liability as aforesaid. Then, if alteration of articles of association has been committed, have been executed, and with the approval at the annual general meeting or special general meeting or at an ordinary meeting, whatever, then certain shareholder may not be liable for such a alteration if the alteration has produced negative results on the company, because of the fact that the particular shareholder has not participated in the decision making of such a wrongful manner. Now, here we have to be very careful, because the shareholder who shall not be liable in such a case still requires to act with due diligence, so that he himself is not responsible or liable for the wrongfulness of the others of the company. The due diligence, in fact, should include that this particular shareholder who would be vindicated has taken all proper steps to prevent any harm being caused to the company. The shareholder also may require to hold or acquire more shares in special circumstance if the certain shares have been put back to the company. Some shareholders who are remaining in the company may be asked to take over those shares. But when the shares have been taken over by a shareholder in such a manner, whatever wrongful manner in which the former shareholder has acted, the present shareholder who has acquired only the shares shall not take the liability of what lies on the previous shareholder. And then former holders of shares on call when call is made and has not provided the sufficient funds for the calls of shares, then the existing shareholders shall not be liable or be guilty of any wrongdoing for the failure on the part of the shareholders who have not met the calling of shares. An interesting case in relation to this is that the Ashbury Railway Carriage and Iron Company versus Rishi. Now, this is a case where a particular company has acted beyond the scope of its articles or acted in ultra vires. The question here is whether this particular company that has acted in ultra vires has committed a wrong so as to make the company liable. Now, what happened in the Ashbury Railway Carriage and Iron Company versus Rishi was a case where the memorandum of association forming the Ashbury Railway Carriage Company stated that its objects were to make and sell or lend on hire railway carriages. So, the objective upon which the company has been created is to make and sell or lend on hire railway carriages, and further that activities beyond the stated objects needed a special resolution passed at the shareholders meeting. So, the articles or memorandum have given particular objects, and whatever the businesses that this company would most likely take at a certain juncture needs still come for approval of the shareholders in a special by way of a special resolution. Now, however, the company agreed to give a loan to Rishi in this case and his brother to build a railway from Antwerp to Tonai in Belgium. But later the company repudiated the agreement. The company said later on, no, we are not liable for this agreement with Rishi and his brother, because it is not a company that can give a loan facility, because according to the objects of the company is to make railways, sell them or lend on hire, and not to give a loan facility to anyone. Here what had to happen is that the Ashbury Railway Carriage had given a loan to Rishi, though Rishi and brother were building railways for the company. These are two different aspects: providing a loan and making or selling or lending on hire the railway carriages. Here what has happened is the company has given a loan to Rishi and his brother to build a railway. The House of Lords held that the company has pursued objects beyond its scope provided by its memorandum of association, and such actions are ultra vires and void. What means by ultra vires? Is that you act without power, without authority, or in lack of authority, or in abuse of authority. If a person commits either of these, he is said to have committed ultra vires, means acting out of scope, acting out of scope. So, if any person has acted in out of scope by acting without authority, or acting in lack of authority, or in acting in abuse of authority, then that person is said to have committed an act of ultra vires. This is a Latin term, act of ultra vires. So, here the court mentioned in the Ashbury case is that by allowing the company to provide a loan to Rishi and his brother to build a railway from Antwerp to Turnhout in Belgium, it has cost the company a loss because of a wrong decision making, where the company couldn't enter into an agreement of such nature, thus acting in ultra vires. Therefore, the agreement entered with Rishi and his brother was declared void as far as the company is concerned, because what the company has done is acting beyond its scope, acting in violation of its memorandum of association that had the objects only to make and sell or lend on hire railway carriages, and not to give loan facilities to build a railway. Acts of ultra vires include acts in excess of power, acting in abuse of power, or acting with lack of power. Now, let me provide some understanding on the types of shares that can be obtained in a company, as well as on the requisites for a articles of association. Now, according to section 713 of the Companies Act, the articles of association of a company may provide for any matter not inconsistent with the provisions of this act, so that no one can surpass the company law with respect to what meant out to be in a company and other than the first schedule here to, and in particular may provide for what the articles of association should provide, the objects of the company, what the company intends to do in its business operations, the objects of the company. Earlier these objects were included in the memorandum of association, but now since it is only one document that a company must have, that is the articles of association considered as the constitution of the company, the objects of the company shall be written first in the articles. Then about the rights and obligations of shareholders of the company and on the management and administration of the company. And these model articles can be found in the first schedule of the Act. And also the articles could be adapted or amended from time to time, as I mentioned. So, whenever there is a new business area to which the company is trying to spearhead, then such amendments could be made possible. Now, what is the effect of articles? The articles of company shall bind the company and its shareholders as if there were a contract between the company. So, we see that the articles of association are in fact a contract between the company, which is the artificial person, with the natural persons who are the shareholders. And also it may make rules to the directors who are appointed as agents of the company. So, it is basically a contract between the company and its shareholders, and it binds the company and its shareholders to act and perform according to the articles. In particular, all money payable by any shareholder to the company under the articles shall be a debt due to from the shareholder to the company. If the shares have not been paid, it remains as a debt on the part of the shareholder towards the company. And under section 17 it says, where the articles of company set out the objects of the company, there shall be deemed to be a restriction placed by the articles in carrying on any business or activity that is not within those objects, unless the articles expressly provide otherwise. Now, this is identically what we discussed in the Ashbury railway carriage case, where you cannot act beyond your powers, you cannot act in ultra vires so as to surpass what I mentioned in the articles. And every shareholder has the right to hold a copy, obtain a copy of the articles as per section 18. Now, I would like to discuss about the types of shares that are there in a company. The nature and type of shares. A share in a company shall be movable property. This is a very important aspect. It is a movable property, which means that it can be given from a person to a person. But how? It is on a document where such share can be transferred from one person to the other. It is not a fixed property like land or building. It is like stocks. Shares in a company shall be movable property. And this share gives the right to vote, as I have mentioned previously. There are different types of shares in a company. First category is the ordinary shares. Ordinary shares in the sense that a share is quite ordinarily acquired by a shareholder, where the price is paid against a share or price is subjected. Share is subjected to a price paid at the initial stage or at a later stage. So, the ordinary shareholders are those who obtain shares for the amount of money they have to pay in raising the capital. The second category of shares are called the preferential shares. In preferential shares, the shareholder is given the preferential right to hold shares, and it is a privilege. There are deferred shares and non-voting shares that would not give any voting power to the shareholders in meetings, and the redeemable shares where the share value could be redeemed. Now, let us look at the statutory provisions with regard to a company may issue different classes of shares, and in particular may issue shares which are redeemable, confer preferential rights to distribution, or confer special limited conditional voting rights, or confer no voting rights at all. So, no share in a company shall have a nominal or par value. It may vary from company to company. A share in a company is transferable in the manner provided for by its articles, and such articles may limit to restrict the extent to which a share is transferable. So, when can a shares be issued? Immediately following the incorporation of a company under section 5, a company shall issue each shareholder named in the application for incorporation the shares to which that person is entitled. Immediately following the issue of a certificate of amalgamation under section 244, the amalgamated company shall issue to each person who is entitled to shares under the amalgamation proposal the shares to which that person is entitled. That is in case of a situation where a company has been amalgamated to another. Then section 55 of the Companies Act deals with calls on shares. When a call is made on a share or any other obligation attached to a share and is performed by the shareholder, the company shall within 10 working days give notice to the registrar in the prescribed form where the shareholder calls for a share, the amount of the call or its value as determined by the board, and the amount of the stated capital of the company following the making of the call. Where the company fails to comply with this requirement, the company is said to have committed a wrong. So, now let me go to the next section under company law, which is the section on directors. I have been telling previously that directors play an important role in a company. They are said to be the managers of a company and also agents of a company when they deal with outside parties. They act as agents. Now, when you talk about agency in particular, there are three main categories of agents. First category of agents are called express agents. Express agents. The agents who have been expressly asked to represent the principal being the company, the directors being the agent. The directors have a duty to represent the company when the company has expressly provided for such directors to make representation on behalf of the company. Second area of agency is called implied agency. That is where the company has not expressly provided the directors the power to represent and to do whatever act necessary. But however, due to the management system, due to the styles of doing business, the directors will have an implied authority of the company to represent such company in whatever decision making that the directors have to take. So, though not provided expressly to the directors, directors may impliedly take decisions. Now, that we have also seen in several cases that have occurred, where the directors have entered into a bond with third parties, like in the Turk case, that later on, even though it is not mentioned in the articles of association that the directors are not empowered to do so, in using the implied warranty, the directors have the power to act as agents of implied. Now, there the directors have to be very careful in acting within their scope, not to act in ultra vires, but have taken certain decision or action based on the implied authority that they have as agents, and have acted in due diligence for the benefit of the company, where the benefit goes back to the company in whatever the actions that the directors do. So, there is implied way where the directors may be made agents for a company. The third aspect in which agency could be created for the directors in a company is by necessity. Necessity in the sense that sometimes the directors will be necessary to take action in the absence of any express or implied authority, but at a certain extraordinary or in any instant unusual, unexpected circumstance, the directors will have to take decisions based on the necessity of the circumstance, acting as the agents for the company. Then in such a case, the agent or the director has to take decisions as of necessity for the benefit of the company, but even then this is subjected to certain qualifications, such as that the director has taken this decision as of an urgency, and where his action could not be reported back to the company in an instantaneous means, so as to obtain instructions and thereby acting on his own conscience to take a decision for the benefit of the company. There again the director have to be very careful, director has to be very careful in order to take the decision based on his entire knowledge and understanding that the final benefit will go to the company and not to himself. So, therefore, the director may act in necessity at certain times when he is acting as an agent for the company being the principal. So, in this circumstance, the directors may act for the benefit of the company, and whatever the circumstance in which the directors are to act, in a company. First of all, let me explain you who shall be a director, or who is eligible, entitled to be a director of a company. There are certain qualifications to become a director. Anyone who has attained the age of 18 is entitled to become a director, which means that in order to become a director, you need to attain the age of 18, or what we call the age of majority under our law. So, no one less than the age of 18 be deemed to be a director in a company. And anyone who is not declared as an insolvent can take up the position of a director. Now, when you say director, it could be working, executive, non-executive, whatever. As long as the person is mentioned as a director in the company's main registration documents, then such a person shall fulfill these requirements or eligibilities. So, insolvent in the sense that the person is not bankrupt, for example. The person is solvent. So, therefore, no one who is an insolvent be made a director in a company. Then anyone who has prohibited to act as director under the former law, that is the Act number 17 of 1982, if anyone has been determined as per that former law not eligible to be a director, mainly because of the fact that while he was a director in a company, he has acted in a wrongful manner. So, that wrongful manner has led to the court or the registrar to determine that he is incapable of becoming a director or acting as a director, then such a prohibition will be a bar to become a director. Also, anyone who was prohibited to act as director or promoter by virtue of operation of section 213, 214 of the former law, then such a person may not be eligible to be a director. I will be discussing about the promoters in my next lecture, but for the time being, I would like to mention that anyone who was prohibited to act as director, promoter by virtue of operation of section 213, 214 of the former law, the law of number 17 of 1982, then such a person is not eligible to be appointed as a director in a company. Then anyone adjudged a person of unsound mind. No person of unsound mind or of lunacy determined by a competent court of law and issued a certificate of lunacy, then such a person is not entitled to be named a director in a company. Any person that is not a natural person is not entitled to become a director of a company. Now, this is very important. Only natural human beings can become directors of a company. But however, you may have heard that when particular corporate body is a shareholder in a company, that corporate body may have certain number of director posts in that company. Now, having certain number of director posts does not mean that it's that particular company or the corporate body who has the director post. No, it is where that particular corporate body appoints 1 or 2 or 3 directors from their side to this particular board. Then this particular board is represented by natural persons of that particular corporate body. So therefore, a director of a company can only be a natural person, So anyone who is not a natural person cannot become a director. A person, anyone who is not qualified under the articles of the company cannot be made a director. That means, if the articles of association in a company says that a particular category of people are not eligible to become directors of that particular company, then such a person is not entitled to become a director of that company. Now, for example, say there is a organization or a company in relation to financial affairs. The articles of association might say that anyone who has been charged or found to have committed a financial malpractice shall not be entitled to become a director of this company. Then in that case, no one of such nature shall be appointed a director of this company. Thereafter, anyone who has been convicted of an offence punishable by imprisonment under the present Companies Act is not eligible to become a director, but only until he passes 5 years after the penalty being or the imprisonment being imposed. If it is an imprisonment, once the person completes the imprisonment period and finishes off, from there onwards for 5 years, that person is not entitled to become a director. Then anyone who has been convicted of an offence involving dishonest or fraudulent act is not eligible to become a director, again with the qualification that after he serves his punishment, from there onwards for 5 years, he is not eligible to become a director. Then in any board of a company, minimum requirement of the number of directors is 2 for a public company and 1 for a private company, 1 for any other company in fact. So in a public company, there shall be at least 2 directors in the board, whereas in a private company there can be a single director. Now, this should not be mistaken in relation to shareholding. This is about the directors. In a board, in a private company, there can be a single director. In a public company, there shall be 2 directors. How can a director be disqualified? How can a director be disqualified? If the director is convicted of an offence punishable by imprisonment, if the director has been convicted of an offence punishable by imprisonment under the Companies Act, then thereafter he cannot remain in the company as a director. He is disqualified. If the director has been convicted of an offence involving dishonest or fraudulent act, immediately he should be removed. He cannot be continued as a director. He is disqualified. If a director is adjudged to be insolvent, if he is adjudged, that is what I said, if he is proved by the court of law that he is bankrupt, a bankruptcy certificate has been issued by the court, then immediately such a director shall be disqualified to act further. He will be disqualified to act. Or he is judged to be of unsound mind, then like lunacy, then such a director cannot remain in the board. He should be disqualified. If the court of law prohibit a person to a director to act as a director further, in Sri Lanka we have seen several examples of such nature, where the court has expelled directors from certain boards, then thereafter that director cannot remain in the board, he is disqualified. Persistently fail to comply with the provisions of the Companies Act. While being a director, if the director has failed to comply, persistently failed to comply with the provisions of the Companies Act, then of course he should be disqualified. If the person of the director is convicted of an offence involving dishonest or fraudulent act abroad, even he will be disqualified to hold director post in Sri Lanka. If he is convicted, or being responsible as a director of a company that was declared as insolvent, or being responsible, now this is very important, not that the person was a director at the time of insolvency of a company, but that person as a director was responsible, that is by lifting the corporate veil, we determine that this particular director is responsible for the company's fall. In that case, this particular director is disqualified to act as a director in the company. So with that, I end today's session, and next day we will be discussing about the promoters of a company, and thereafter we will be discussing other areas of importance under company law. Thank you very much for listening, and let's meet up with our next lecture tomorrow.